All right. Good afternoon and welcome everybody to our webinar on sea level rise between responsibility and protection. My name is Maximilian Bertamini and I will be the moderator of today's webinar. On behalf of Ruhr University's Institute for International Law of Peace and Armed Conflict and its research cluster on humanitarian governance and management, it will be my pleasure to take you through our webinar and introduce our distinguished experts on a variety of legal and humanitarian issues revolving around sea level rise in a minute. Before doing so, however, I would also like to address and welcome our digital audience for today. When we set up this webinar, we received quite a number of registrations from all across the globe, essentially, and we're as humbled as we're motivated by the fact that indeed so many people are interested in a topic that certainly deserves and frankly also demands quite a lot of international attention. We are very happy to take all of your questions that you might have in the second half of this webinar. Feel free to submit them at any time in the Q&A chat that you should find down at the bottom of your Zoom screen. Should you want to make or respond to a point verbally, I think that should be an option as well. In that case, just raise your hand virtually in the second half of the session and we should be able to unmute you. With that being said, thank you for tuning in and we will now move towards our first presentation. Sea level rise between responsibility and protection is the title of our webinar, and when we talk about responsibility in international law, it is very hard to miss the expertise of our very first panelist, namely Professor Volker Röben. Volker obtained his PhD from the University of Kiel and qualified as a professor in Heidelberg, where he also spent 12 years as a senior research fellow at the Max Planck Institute for Comparative Public Law, for which he also serves as a board member today. Volker's previous positions as a professor and his affiliations have taken him all around the world, including stays at the China University of Political Sciences and Law, Turku University in Finland, Swansea University, and the University of Houston. Since 2018, Volker holds the chair for Energy Law and Global Regulation at the University of Dundee in Scotland, from where he joins us today. In his previous publications, Volker has dealt with a broad number of environmental issues in international law, but at the same time also contributed substantially to a number of concepts of international legal theory. What stands out in his academic career and his publications is his ability to combine these two areas of expertise into thoughtfully crafted academic arguments with a very strong relevance for real-world environmental issues. Volker, we're looking very much forward to hearing from you, and you have the floor.
Yeah, thank you very much, Maximilian, for this introduction. I'm delighted to be here and sharing this this panel with you on this indeed very salient topic. So I'll be speaking for about 10 minutes now, and then hand over to my colleagues. And what I will be saying is effectively 3 points, or we're speaking to 3 points. I'll very briefly set the scene about what I think are the most salient issues of sea level rise from the topic that we will be covering here. Then I'll say something about responsibility in international law, and then I'll draw some conclusions and applications, or possible applications for our problem. So all of this very quickly, but hopefully not too superficially. So the first step now is about getting a sense of what the salient features of the topic are. And I think what's critical is to see that sea level rise is a reality and effectively across the world. But there are a number of things I want to highlight. First of all, the main cause that's often overlooked, the main cause of sea level rise is simply thermal expansion. So effectively, the seas are warming, and that means the level rises. That's the first. It's not this melting of the polar caps at this point. It is simply thermal expansion because the climate has been warming. The second point is that while the effect is almost egalitarian, because the sea, as you know, covers most of the Earth's surface, the effect is disproportionate on falling on certain, often vulnerable regions of the world. Obviously, it does concern all low-level or low-lying countries, such as the Netherlands or Northern Germany. But in fact, it is particularly relevant for all countries that that are completely surrounded by the sea, so island states. And many of those are developing countries. So that's the second element, it's a disproportionate effect, compounded often by lack of development. And the third issue is really that sea level rise is both an issue of prevention and protection or adaptation, as I will point out. Now, these are the three factors that we need to take into consideration when we talk about responsibility. So next point now on my brief presentation is about what the definition of responsibility is that I think is most interesting in our context. Now, as international lawyers, we think of responsibility as a matter of the responsibility of states, that is effectively the consequences of wrongful action. So as you all know, under customary international law, states are responsible if they violate obligations incumbent on them, and then there are certain consequences attached to this, mostly effectively rights of other states that are affected by that breach of obligation. But that's not the sense in which I want to use the term here, because responsibility, in fact, has a broader meaning as well in international law, and it sits at a, if you want to, at a higher level of abstraction than this concept of international responsibility of states. In the sense that I want to use it, and that is the sense that is also increasingly being used in the doctrine, is not related to wrongfulness necessarily. Effectively, is a question of organizing the response of the international community to certain facts that they need to address. So responsibility in this sense has much to do with the other side of sovereignty or freedom of action. It curtails and limits that freedom of action. So it sits at an institutional level. It's one of the institutions that governs this maturing legal order we're talking about when we speak about modern international law. And that is an institution, that's the term, effectively being built around an idea. It combines an idea with a reality. So what is this idea? I think the idea is relational. It's about three questions: who is responsible, who is responsible for what, and then finally, who's responsible to whom. So these three questions, or these three questions, constitute the key idea of responsibility as an institution. And I have no time to go into this, but you can actually prove the rise of this idea, the motivating rise of this idea across a number of areas of international law. So who is responsible to whom and for what? That's the idea, but it's not necessarily so that the institution is law generating by itself. And that's an important point. Actually concretizing this into law requires further decisions, further actions, both legal, treaty making and national courts, and even also on the domestic level. So that's the scene, that's the term in which I want to use it. And now, if we apply this to our context, then we need to ask. Obviously, the question is, if we wonder who is responsible to whom for sea level rise prevention and possibly taking other action. Now, who is responsible? You could say it is the states themselves that are concerned, but in fact that would be obviously too short in answer. If it is true that the sea level rise is a question of thermal expansion, which is a natural fact, then effectively the responsibility falls on all states to prevent further global warming that will then lead to the sea level rise. So who is actually a very important question here? It's while the effect of sea level rise is disproportionately falling on certain states, responsible for its prevention are all states that can do something about climate change. So effectively by limiting particularly global emissions. So that's who. The question is then, for what are they responsible? I think there's two answers to this. One is clearly prevention. That means states have to take action to minimize the emissions that then will lead to carbon emissions that will then lead to global warming. Secondly, they are also responsible for taking the inevitable into account and taking adaptation measures. So to a certain extent, the sea level rise is inevitable. It is going to happen even under Paris Agreement, because we know that we will not completely halt all temperature rise, only limit it to 2 degrees, possibly 1.5 degrees. So there will be a further warming, and that means there will be further expansion, there will be further sea level rise, and that immediately raises the issue of adaptation. And to whom now are states responsible? Well, first of all, they're responsible to the collectivity that is organized in the UNFCCC and also the COP and the CMA, so that's the meeting of parties to the Paris Agreement. But I would make the case they're actually also responsible for those states that are particularly affected by sea level rise. I think that's an important consequence of this disproportionate effect. So if you go to Bangladesh, for instance, you see immediately, and I work closely with these people, you see clearly that sea level rise is a direct issue, salination of the territory. And it's clearly it is therefore a responsibility towards those states that are particularly heavily affected. That's a difference from many other areas where we see this institution rising, that there is, if you want to, a targeted holder or beneficiary of this responsibility. But that shouldn't take away the fact that everyone is also responsible to the international community as it is organized, particularly in the climate change regime, but also the UN General Assembly. So that's leading us. That sets the scene of the responsibility to prevent and mitigate the climate, the sea level rise for certain particularly affected countries. So who, to whom, and for what? The for what could actually also be expanded. This is a very interesting question that I think my colleagues will address. There may be more what states are responsible for than prevention and mitigation and adaptation. It may also be actually finding new legal solutions to losses of statehood and other issues that my colleagues will speak about. And I said that the final element of responsibility is always that it is by itself not legally enforceable. It requires further decisions that put that responsibility into, if you want, to hard law. So where is this going to happen? One way might be to go to the no harm principle, but that is still, that's a customary law principle. But it's not clear yet that will actually have broader traction than simply transboundary harm. But we're dealing here with a global problem, so no harm may not help. And therefore the legal concretization of responsibility, I think for the time being, is indeed the international climate regime. So here, very specifically, it boils down to the adequacy of the so-called nationally determined contributions that states have to notify and ratify under the Paris Agreement. The situation right now is not the happiest. I think we all know that not enough is being done, but there's still time in time for the next COP or CMA in Glasgow. We'll see possibly a further increase in ambition here. But that is the place where the legal obligation, where the responsibility is being concretized into legal action. And we could go into the details about to what extent these decisions of the CMA are binding and so forth. I leave this here out because it's too detailed, but it does demonstrate the need to concretize responsibility. The final point I wanted to raise here is responsibility as we normally know it in international law is a matter of states. States are responsible and they are responsible to the international community. But in fact, in this field, what you're seeing is an expansion of this towards private actors. And that simply has to do with the fact that if you look at it, climate change is actually to a large extent due to a number of big private players, companies, the major emitters that often substitute for states. So it's a very interesting question then whether we break down this institution of responsibility of states towards those private actors. That's very much at the forefront of some very interesting developments. And I'll end on one interesting case that's pending before the German courts right now, where a farmer in Peru in the Andes region is bringing a case against the big German utility. And the ask here is not to stop the emissions that this utility makes when producing electricity. The ask is for adaptation measures to stop a certain, a glacier lake from overflowing as a consequence, in this case, of a melting glacier. Now, I don't want to speculate on the outcome of this case, but it does demonstrate that the institution of responsibility here is, so to speak, being broken down and pierces the sovereignty level and actually is starting to hold the private actors responsible for adaptation measures. So I'll leave this here for the moment, and I look forward to hearing from my colleagues. Thank you, Maximilian.
Thank you, Volker, for this very clear and analytical contribution on responsibility and climate change. I think I have not promised too much when I said that you do, in fact, possess the ability to combine legal theory and environmental issues to a very impressive degree. So to make a transition to our next speaker, I would like to pick up a point that Volker made regarding the responsibility to whom. And I think it is sort of a occupational disease that we international lawyers have, and that we think very much in terms of states and the community, but what states in fact represent is, of course, human beings. And I think the focus on human beings reflects the fact that climate change and its causes do not only affect the environment and states, including wildlife and vegetation, but of course also human beings in two ways, namely, of course, in our individual rights and our livelihoods, but also, and this sort of closes the circle then again, as the states through which we determine and constitute ourselves. Against the backdrop of this effect that climate change and specifically sea level rise has on human populations, it should not come as a surprise that the United Nations International Law Commission's attention was also drawn to the matter of sea level rise. And we are very lucky today to have with us not only a sitting member of the UN's International Law Commission, but in fact one of the members who actively put sea level rise as an issue on the ILC's agenda and is now one of the co-chairs of the ILC's working group on the subject. I'm talking, of course, about Professor Patricia Galvalde, who is here to join us and talk about her perspective and the ILC's work on sea level rise. Patricia is not only an ILC member, but she's also a member of the Permanent Court of Arbitration and a vice chair and chair, respectively, of the European Council's Working Party on Public International Law and its subgroup on the International Criminal Court. Patricia is, of course, also a professor for international law at the Autonomous University of Lisbon. Before obtaining her PhD from the Graduate Institute in Geneva, Patricia already gathered experience in legal consultation to the Portuguese Foreign Ministry, which she left in 2008 only to serve as an advisor to the permanent Portuguese representation to the European Union in Brussels, before she eventually made a switch again in 2015 and returned to the Foreign Ministry as a senior legal consultant. Patricia has already also published on a broad variety of issues of international law, but it is safe to say that she's today fully committed to the topics of sea level rise, statehood, and protection, especially considering that it is states that face the possible extinction due to a submersion of their territories. Patricia, we are very much looking forward to hearing from you, and you have the floor.
Thank you so much, Maximilian. Thanks for that kind introduction. Thank you for putting together this event and for the invitation to be a part. I'm really happy to be in very good company, and I hope that our audience also enjoys this discussion, as I'm sure we will. I want to focus my initial remarks, since I'll go on for about 10-15 minutes to leave ample time for discussion afterwards. I want to focus my remarks, as you said, in the current work that we are doing at the International Law Commission concerning sea level rise in relation to international law. Of course, the points that Volker just eloquently made about responsibility are extremely important, but they are not being addressed in the current work of the Commission. It's not that they don't matter, of course they matter very much. It's just that when we presented, and as you said, Maximilian, I was involved together with a group of other 4 colleagues in putting together a proposal back in 2018 for a new topic for the ILC. And we decided to focus our work on 3 subtopics, which are the issues related to law of the sea, the issues related to statehood, and the issues related to the protection of persons affected by sea level rise. And this also following from very important work that the ILC had conducted before already on the protection of persons in the event of disasters, where a set of draft articles were finalized in 2016 and are now in the hands of the 6th committee for discussion as a possible convention, and also following the leading example of the ILA committee on sea level rise and international law, of which I'm also a member, who started even before the ILC looking into the international legal aspects related to sea level rise, first as an issue mainly related to the law of the sea, but then also expanding its mandates to deal with the statehood and also protection of persons. So we've started working against the background of the increasing relevance of sea level rise as an adverse impact of climate change, given the scientific facts that indicate that sea level rise is already happening, and it will continue to happen, and will probably happen at an increase and accelerating pace in the future. And also because of the impacts that this specific effect of climate change will have in the 3 elements of the state, both the territory, the population, and government. And that's why we focused on these three subtopics, because they are the ones that we consider that are interrelated in the sense of affecting the state as a whole. We were also very much encouraged, and I think this is an important point because it's not always the case, when it comes to the International Law Commission, where a lot of times the topics are chosen according to a proposal of a member and discussed internally in the Commission, and then they make it to the Commission's agenda. In the case of sea level rise, there was strong encouragement and support from member states of the UN. And in particular, there was a proposal, which is not something very common in the life of the ILC, a formal proposal by the Federated States of Micronesia, as of course a especially affected state in this context, for the inclusion of the topic. So this really explains why there was a group of members that were interested on the topic, because they were sensitive also in the conversations, informal conversations that we have with member states, and also listening to the statements that were being made in the 6th Committee of the UN General Assembly. And this specific proposal of Micronesia, we made a proposal to include the topic on the agenda. This was done, as I said, in 2018, made it to the long-term program of work. And then the next year, again, with strong support from member states, is now, since 2019, in the active agenda of the International Law Commission. Because of the nature of the topic, the fact that it's a new challenge, the fact that it's probably not, the classical topic that the ILC deals with, because practice is arising and developing, and because of this three-dimensional nature of the topic with the subtopics, we thought that it was a good idea to have a study group and not a traditional format of a special rapporteur making proposals for a draft convention or doing conclusions or principles, but we thought we would do, at least as a first moment, and this is the mandate that we have, a study that would map the legal questions and that the legal issues that arise from sea level rise, and try to identify and some legal solutions. And here I think an important point that Volker made about what can be done. And I think one of the aspects that we would try to explore precisely is to see how having a more clear and a more robust legal framework can also help states and affected populations to deal with this impact of climate change. So international law, in a way, as an adaptation form in this sense. So the idea is to do a mapping of the legal issues, to try to outline some conclusions, some recommendations, and then, of course, put it back in the hands of states to see where do we go from now. So what we're doing now is working on the first subtopic, Law of the Sea. There's been a first issues paper that has been produced, and we will discuss it this summer, but I'm not going to focus on those aspects. I will focus more on the statehood aspect and on the protection of persons, because I think, as you said, also they're quite interlinked. I mean, the state, of course, is about territory, but also the state is about the persons, the people that live in that state. So I'm going to focus on those aspects. And also because the way we distributed the work, I am responsible for the subtopic of protection of persons, but I'll be working closely together with my colleague from Peru, Juan Jose Ruda Santolaria, who is the colleague that has the lead on the stated issues. And we will be presenting, not this year, but next year in 2022, we'll be presenting a first report which will deal with statehood and protection of persons. So what type of things will we be dealing with? What we will look at in terms of trying to map the legal issues with regard to these two subtopics. On statehood, I think the big question, and because of the impacts that sea level rise may have as a slow onset event. Of course, in certain cases, in the most serious consequences in the long term, it may lead to the physical disappearance of the state. That's why sometimes we hear the expression of sinking states or disappearing states, which I don't think it's a very happy expression, because it's one that really is condemning the fate of those states and not taking into account what may happen in the meantime if good measures in terms of mitigation and adaptation are taken. So, but in any case, and this could happen in some, not all of them, but in some small islands in the Pacific or in the Indian Ocean, it could be possible that in the long term the territory will disappear, it will be completely submerged, or even in the meantime it would become inhabitable. So this may be, you know, a slow process that creates the type of conditions where it's no longer, or it's very difficult to inhabit in a certain territory. So the question, of course, and this is something that has never happened, the question that arises, the legal question is that, I mean, do we still have a state if the territory has disappeared or becomes uninhabitable, looking back at the Montevideo Convention and the 3 elements of the state, and recognition, which is, of course, an important 4th element. The question is whether there's continuity of state or statehood. Is there a loss, a disappearance of statehood if the state is completely covered by sea or becomes inhabitable? What would happen to the population of that state? And what would be the possible solutions in terms of creating a legal fiction? That's one of the things that is sometimes being discussed, of continuity of sovereignty, so a state without territory. Some people are calling it nations ex situ, trying to create a fiction of continuity of sovereignty, and also some possible solutions of merging of states in the territory of a state that would not risk disappearance. So what we'll have to look is that, and here it's difficult because there's no practice. I mean, there are some indirect examples, like the example of, the governments in exile, temporary situations, or the example of the Sovereign Order of Malta or the Holy See, where you have international legal personality without the territory. So these are the kind of things that we'll have to look at to see what would be the possible legal implications. But of course, the question also then arises to the protection of persons, and there, of course, it's one important aspect, and I think then Sanne will explain better in terms of more of a humanitarian perspective. But in terms of the protection of persons affected by sea level rise, I think it is very important also to clarify that we have already now a number of legal principles and legal norms that could be applicable in order to protect such persons. Although the idea that many people sometimes speak about climate refugees does not have a legal basis under the 1951 Convention, but we can find in the applicable legal frameworks like international human rights law, in the international disaster law, international climate change law, we can certainly find some applicable principles that would direct us to protect the persons that are affected by sea level rise. There's been recently a very important decision by the Human Rights Committee, although in the case in the case that was being decided, the decision was it was that we weren't yet in a situation where the person could not be deported back to the country where he was trying to seek refugee status. This is the Tetiota case. But where the Human Rights Committee said that in the long term, if the situation, in the long term, I mean, the time span was 1 of 15 years, so it's not that long term, but if the situation deteriorates to a point that there may be an obligation for states of not to deport people back to the countries of origin. In this case was Kiribati, under the non-refoulement principle, so an important protection under that principle. But even for states that are states that are directly affected, the principle of protection of the population, trying to keep the population in situ, trying to relocate under certain legal principles that would be applicable. The question also of the application of international cooperation, the principle of international cooperation for other states, third states, to help in, for example, relocation and migration schemes if it comes necessary. So this would be the type of questions that we'll be looking at, both look for the aspect of statehood and for the aspect of the protection of persons affected by sea level rise. And hopefully when we finish in a few years, there will be a study with a mapping and an objective mapping of the legal issues with some recommendations that could help then to create this more clear and more robust legal framework for states and the international community in general to deal with the issue and prepare better and try to avoid even a worsening crisis that climate change and in particular sea level rise is creating. So I would stop here and I would then be very happy to engage in a conversation. Thank you.
Thank you so much, Patricia, for the very hands-on insights into the work of the ILC. And I think we can all agree that we are very much looking forward to seeing the study once it is finalized and see where the ILC comes up with a few suggestions to tackle the problem of sea level rise from a legal perspective. So now, without wanting to take anything away, of course, from the two brilliant presentations that we have enjoyed so far, I think it also should be clear that a problem as serious and as complex as climate change and sea level rise in particular cannot be solved by only rules and ideas, and certainly not by only one discipline alone. What arguably matters most to the affected populations is the protection and the aid that actually reaches them. Providing and facilitating such protection is, metaphorically speaking, a crucial link in the chain that affected populations can hold on to in order to keep themselves above the water. And it is this work of humanitarian action which translates the humanitarian ideas and ambitions into reality. And in doing so, humanitarian action will often unearth that certain issues, in theory, were over or underestimated, or maybe not even properly considered at all. And so, in other words, humanitarian action is not only a realizer of humanitarian ambition, but may also serve as a reality check for them, which is why for an event such as ours today, the perspective of humanitarian action must not be missing. And we're extremely fortunate to have Sanne Hoogestera on board with us to represent the perspective of humanitarian action. Sanne is perfectly qualified to do so since she received her bachelor's degree from the University of Leiden and afterwards successfully completed her master's program in the NOHA Master at the Universities of Groningen and Ruhr University's Institute for International Law of Peace and Armed Conflict in 2014, before she took a position at the Red Cross Red Crescent Climate Center in The Hague, where she is still working today. She has held several positions there and is currently a program coordinator for the Partners for Resilience program. Sanne, we're happy to have you, and we're looking forward to hearing from you about the perspective of humanitarian action and sea level rise. You have the floor.
Thank you so much, Maximilian. And it's really nice to be here today. And I'm learning a lot as well going into this webinar myself, having not a strong legal background, but indeed a more focused on practice. Before, I want to give you a couple of examples of what the humanitarian sector has been done to help people at risk of sea level rise. I want to share a few pictures mainly and share with you a story, which I think we can use as a good reality check, indeed, as you said, of what's happening in reality. So allow me to share my screen. see. There you are. Oh, I have not been able to share my screen.
Give me a second, I'm trying to fix that. Okay, I've now made you co-host. Maybe try again, it should be working.
Yes, this works fine, thanks. So what you see here is Miss, oh, sorry, 2 seconds. Yeah. So Miss Kaman is what you see on the picture, so the lady on the left. And in August of 2018, I was visiting India for indeed the Partners for Resilience program to visit the project sites of where we are implementing the program. And in the state of Odisha, we were visiting the coastal village of Gogarkuda, which is where Miss Kaman lives. And she's a mother of 3, and her husband is a fisherman. And their families rely heavily on the fresh and dry fish for their daily income. But due to a couple of challenges over the years, the income has not been proven enough to maintain their families. And she told me that the seasons had changed quite dramatically, and they're experiencing more stormy days. And this village that they were living in was at high risk of cyclones. And both the storms and the cyclones made that her husband could not go out to sea as much to fish. And even on the days that they had good catch, then no way they could store all the fish that he catched. So they had to get rid of most of it because there was no cold storage. And then finally, she learned that the middleman that she would sell her fish to was not giving her the right price and was cheating on weighing her fish while it was her only way of selling. And then the village that they're living in, this is a picture you see here, was even experiencing more risks, and one of them being sea level rise. On the picture, you see on the right, their freshwater supply, and on the left, salty seawater. And what they were experiencing was problems related to saltwater intrusion. And during cyclones and those stormy days, they would see higher storm surges and bringing more water inland. So when you're wondering maybe, okay, so who's then responsible to help this community, help Miss Kaman? Who should be the one addressing the risks and the problems? And while I think, those conversations should happen, there's a lot of humanitarian actors that want to act now and help those communities that are just having a hard time making ends meet, or even staying in the position that they want to stay in their village. So what we did is we were starting to assess all the risks in the community and try to approach them in an integrated way. By the end of the presentation, I will tell you what we've done in the communication in this community and what we did for this family in particular. But what I want to just show you in general is that humanitarian actors more and more start to understand that they have to assess these risks in a more landscape approach. We're using this image, although there's no sea here. I think it does reflect how you should indeed look at this landscape, because rains upstream and maybe and the communities that are living there are having an effect on people downstream. And when the risks change upstream, it changes downstream. And if you only had looked at downstream communities and you would have maybe did something for them there, it would not have been a durable and long-term solution. So we look at more a landscape approach. At the same time, we look at the state of the ecosystem. So in particular, wetlands, and how is the land being used? Can you tell something about the risks of landslides, soil erosion, the absorption capacity of rainwater or other kinds of water? And then finally, we look at the makeup of the community and the stakeholders within those. What type of people are there? What's their daily income? What type of businesses are there? To ensure that we come up with solutions that are not just relevant for a few people, but are relevant for the community. Keeping in mind that as humanitarian actors, of course, we focus mainly on the most vulnerable people. And then finally, when you're taking this landscape approach, we're also looking at risk across timescales. And I think what we're discussing here today is the long-term projections of sea level rise, for instance. We definitely know sea levels are rising, but and they're very likely to rise for the rest of the century. But we don't know specifically how much and where and what the biggest problems will be. While indeed, if we get a weather forecast for a cyclone, we can be a lot more precise about where and when this extreme event will occur. And that means also maybe less time to reduce the risk, but we at least know specifically where to reduce risk. But also for the longer term predictions of sea level rise, we know that we can reduce risk in those areas that are going to be affected by reducing sand mining, for instance, protecting or planting mangroves to avoid erosion. And yeah, there's a couple of those examples to be given. So I think what I'm trying to say here is that just trying to address the sea level rise alone, it's always good to see it as part of a bigger problem in most communities. Again, I'm not talking about just these island states that indeed I think we also should touch upon, but I'm again going back to the village in India. So then there's a role for everyone to play, I think, in reducing risks. And I think we have discussed at length and will discuss more about the roles and responsibility of the legal sector as well as states. But I wanted to talk to you a little bit about the role of the Climate Center and what we do and what the Red Cross maybe is doing. As a Climate Center, we are a broker. We're trying to bring together the right people to help those most at risk. And we are an organization that builds the capacity of others that are involved in this field of work or want to be involved in this field of work. First and foremost, what we do is we help build early warning, early action systems. And that is something that, at least for those people affected by cyclones and typhoons, and again, also the storm surges that are increasingly becoming a risk even with sea level rise, can be a short-term as well as a durable solution, because those systems, if they're robust, can help communities for a long time to come to save lives. Then furthermore, we ensure that governments, that with the interventions they are implementing, they're taking into account those most vulnerable people. And this is in a picture of the Philippines. So after Typhoon Haiyan, in 2013, the president of the Philippines in all coastal areas said there would be a no building zone for 40 meters. And this enforced the local government units to then take this decision that he made as president to replicate it in their localities. And that resulted in 205,000 families being permanently reallocated. And the government also stated they would no longer assist communities that are living in those no-build zones. And then what we did as Red Cross, as part of the humanitarian country team, they work with the Philippine government to allow that at least the humanitarian assistance would still be given to those people at risk in the no building zones. And they advocated strongly to consider the measure of relocation as a last resort, and that hazard mapping should be carried out to identify other solutions and those at risk. Then one more thing is we broke a relationship between the National Red Cross Societies and their meteorological and hydrological agencies. It's a conversation that a lot of humanitarians are not having enough. And while those institutes have the scientific knowledge that we can use today to reduce risks. And this is an example from Indonesia, where this is a village that was flooded on a seasonal basis. So they're used to flooding. They built their houses on stilts, their freshwater supply also on stilts, and they made taps at the bottom and taps at the top. And taps at the bottom were for the dry seasons, and then for the flooding seasons, they had the taps at the top. However, if we would have known this in advance, and again, this is the village when it's flooded, we would have had a conversation with the implementers of these water tanks beforehand, because what they did, they built these higher taps based on historical knowledge only, and not so much on future projections. While this is what happened a few years later, and the taps are no longer being used or they couldn't be used because the flood levels were even higher. Again, that doesn't maybe speak about sea level rise, but I do think it gives a good example of things we can practically do for communities. And then finally, we work, at least in the program that I was coordinating, with environmental organizations, because they have a strong environmental expertise that we as a humanitarian sector don't always have. They know a lot about mangrove restoration, for instance, or planting of mangroves. They even know more about other nature-based solutions that we can do to reduce the risks in the short term. So yeah, I think, a good example of we don't know all of it by ourselves, and it requires a lot of cooperation. And then just out of interest, I think it's good for those people interested in the Climate Center more broadly, is we do 3 more things, and some of them touch upon what Volker and Patricia already were talking about, is international and national policy dialogues. We are there present as Red Cross to ensure that whatever is being committed to, or what intentions are being shown, are reaching the most vulnerable, because often what we see is that there are really good intentions and really good commitments also within the NDCs, but those most at risk now are being left out, are not being part of conversations, and it's what we are trying to do as well. And then at the local, more national dialogue levels, we are trying to promote that the allocation of funds and resources are really going to the local level, because that's often left out. And then we work with academics, and that's where I'm almost going back to Gogarkuda, so bear with me. But what we do is we try and ensure that the academic research is going to be as relevant as possible to reduce the risks for the most vulnerable people we know now, and those that are going to be most at risk in the future. And two of our staff members currently are co-authors of the IPCC report that's coming up. And they really are there to ensure that, at least for the adaptation side, there is a strong focus on ensuring that that's done to increase the resilience of the most vulnerable people. And they're engaged in these conversations around geoengineering. I know we're not going into that today probably, but that's also a very interesting legal question about where we should go in the mitigation agenda, where geoengineering is being brought up as an option. And we are seeing, as humanitarians, quite a number of risks that I don't think are fully addressed yet. Let me finalize my story by going back to Gogarkuda and what is it that we did there. I think it's a good example of where, in a locality, in a bigger landscape, different institutions and different people came together to build the resilience of this community. Again, first we mapped challenges and risks, cyclones, storms, saltwater intrusion, coastal erosion, violence against women. There were a lot of different things at play here. Then first of all, and you see this in the picture, is the cyclone shelter with a really great early warning system implemented by the German and the Indian Red Cross together. And this community is so well at evacuating that they haven't experienced any losses after this cyclone shelter was built. Then the government in India is actually quite good at allocating funds for all kinds of adaptation, but communities are often not aware of them and are not known how to access the funding that the government is making available. So what we did is help communities getting organized, women groups coming together, so that they know how to access the funds and also know when new funds are coming and how to access those. And then they bought better fishing boats, had bikes to go to the market to skip the middleman. Cold storage was installed so that they could have a more sustainable income. And we worked with an environmental organization locally to India that is helping them to reinforce their embankment, protecting their freshwater reservoir. And they also started creating a protective mangrove buffer along the shore. Today, she is doing a lot better. She is getting, for instance, 50 rupees for a kilo of fish instead of 20. That's actually a big improvement. And she really also told me at the end of the visits, my life has improved. We are better organized. We have addressed multiple risks in our community and have seen the linkages between different sources, different reasons for these risks. But she also told me, look, I know that the stormy days will only increase, and I don't know yet if this is a long-term solution, although my situation has been better now. And that it didn't leave me, that story. So when I was in the car back home, I was talking to one of the partners there, and I said, okay, but how can we ensure that this is even becoming more sustainable? And they said, yeah, we're also looking at alternative livelihoods for them, like mushroom farming. Again, it is not a beautiful story. It just shows how complex it is. And it does give a few examples of what it is that we can do as humanitarians. It is a clear example of cooperation, local government, communities, civil society, all coming together to try and address risks in a holistic way. This is what I wanted to share with you today, and I'm very, very keen to see where the conversation goes.
Well, thank you so much, Sanne, for completing the picture in terms of highlighting once again the human element, I would call it, but also in providing the practical insights, which I'm certain will inspire a lot of lawmakers regarding intermediate measures that actually help and that should be considered, but also regarding having the, as you would call it, necessary conversations with actors from regional and local levels, but also with academics and scientists from other disciplines. So thank you very much. And thank you once again to all our speakers, because this now concludes the first half of our webinar. And with this, we will now move over to the Q&A section of the event. And we indeed already have a couple of questions, which I will raise to you next. So the first question that we got was from Jan-Philipp Graf, and I believe it is addressed to the panel as such. And he asks, what role does the expertise of environmental scientists play in the development of both legal and humanitarian solutions to sea level rise? Because one cannot outlaw sea level rise, right? So that's a very interesting question, and I'm curious to hear what your response to that would be. In no particular order. Whoever wants to respond first, just go ahead. Yeah, Patricia.
I don't mind at all starting. No, thank you so much for the question, and I think the presentations complemented each other very well. Gives you different aspects, some more legal, others more hands-on, but I think they're all really important. And the science, I think the science is also, it's something that we didn't address in detail, but I think it's also a very relevant part to this issue. I had never thought of the idea of outlawing sea level rise. That would be a good solution, but it's just not practicable. Even if we did it, that it would continue to happen for sure. So the way we view this, the issue of the role of expertise of scientists in the Commission, in the ILC, is that we take, we take the existing science for facts. I mean, we're lawyers, we're not discussing the science. It's not our role to discuss the science, but we pay a lot of attention to it. And in fact, what we did already in 2019 was to invite one of the members we have, because we meet, the ILC meets in Geneva and the IPCC is also based in Geneva. We are fortunate that we can have also some kind of interaction. And so as soon as we put the topic officially on the agenda, we had a session with one of the members of the IPCC that came to speak to the full commission, not just to the study group members or chairs, but to the full commission. We had a side event about the science behind sea level rise, so that we understand, we try to understand, although we're lawyers, we're not scientists, we try to understand what's happening and to understand better the scientific phenomena, so that we can look at it in a more informed way when we are thinking about the legal solutions and the legal impacts. And another very important, I mean, the whole work of the IPCC, and that's what really we use as reference, because also being an intergovernmental panel, having this very thorough process, and which is a part of it scientific, but also part of it political. But it's really what we use as guiding science on this matter. Knowing that, and I think that's for people that are less familiar, knowing that the data and the estimates that we get from the IPCC are generally conservative. Because it's the agreed positions, and normally they go for the more conservative, and you can see where there's high confidence, where there's low confidence. You can understand a little bit, what's more likely to happen. But one of the things that is also quite relevant, so in terms of, completely agree, the role of the expertise of scientists is fundamental. In 2019, the IPCC published a very important report for the issue of sea level rise, which was the report on the ocean and the cryosphere of September 2019. And so this report is also very important in explaining some of the things that we hinted at, like it's happening, it's accelerating, it will not have the same impact everywhere, but it will have an impact in small islands, the developing states in particular, but it will also have, and this is, I think, something that Volker also alluded to, and the examples that Sanne gave, for example, with regard to India, it doesn't only affect small island states, it will also affect low-lying coastal states where you don't have the problem of the possible disappearance of the state, but where you will have certainly population being affected and need to be relocated, moved in order to be protected. And so it's very important that we look at the scientific aspects, that we understand better the phenomena. But of course, it's not for us lawyers to discuss the scientific basis, but this is how we've been approaching it from the ILC point of view.
Yeah, let me, Maximilian, just very briefly complement this. I think Patricia is alluding to a very important phenomenon here. In this field, I think for the science is becoming a driver of international law and policy like we have never seen it anywhere else. The deep rationality that this is infusing the process with is really remarkable. And again, as Patricia said, the interesting thing is that it is institutionalized science in the IPCC, which has been so important. And the question is, how can the law actually effectuate the legal insights? There's a number of interesting questions that arise from this, but overall, I think this is indeed a remarkably science-driven process, both in law and policy. Thank you.
Sanne, do you want to go ahead and make
I saw more question coming in, and looking at the time, I'm happy to move to the next one.
Okay, very well. I believe the next two questions can be combined because they relate to responsibility and corporations. I will read them out and try to summarize them a little bit. The first one is raised by Pierre Thielberger. He writes, thanks to all three speakers, it was excellent. My question relates to the responsibilities of corporations that was mentioned. How should corporations be held responsible? Either through national law, for example, the German proposal for Lieferkettengesetz, or maybe with new international rules. And he mentions the initiative for binding legal instruments on business and human rights, whether or not the emission of greenhouse gases should be included as a factor in this proposal. And this question should, I guess, be combined with another question posed by Dennis Dijksel, who specifically addresses this to Volker and asks how the private companies are reacting to attempts to establish their responsibility, whether they are merely issuing lip service, or is there actually a response in a constructive way from them?
Yeah, I think that's addressed to me. I'll start with the last question, which is fantastically interesting. How do they react? At Dundee, we're obviously particularly concerned with the reaction of energy companies, the oil majors. They actually drive much of what is going on. Now, you can find in the recent strategies of these companies, Shell, for instance, BP, but others as well, a surprising realignment of the entire business program with the Paris objectives. There is, it's not perfect, but it is. All of them are going for net zero at one point or another. Most of them are reinventing themselves as international energy companies rather than oil companies, and that's a remarkable development. It's both a question of top-down pressure from governments acting consistently and irreversibly under Paris, but also, of course, bottom up from shifting consumer preferences. So I think companies, in particular in that sector, are reacting very strongly, and that, to a certain extent, is the most important signal, authority signal from the Paris Agreement. It's not just governments; it's actually the private sector that is the ultimate addressee of this, and you see evidence of this happening. The second question is about putting more specific legal yardsticks or standards on companies, and the guiding principles were mentioned. This is tremendously interesting because it is effectively a tool to direct much of what we have developed in terms of human rights, responsibility, and also humanitarian law, really, towards away from states towards these private actors. I'm not entirely sure whether a convention is necessarily the best way here, but we can discuss this. But the principles have that purpose. There's also, and there's no other way, because, as I said, to a certain extent, they substitute for state actors in this field. But the other thing is also, there's a very interesting further development, that is often called the just transition. And that's a framework of holding companies accountable for the facts of their actions, particularly in vulnerable regions. That is what's called a social license to operate, and adds another tool or another arrow in the quiver of law to hold these players accountable. It's often overlooked, but it's very important, and is now often is being enshrined also in national legislation. So it's a surprisingly strong development in law across a number of instruments to bring about this major redirection of human rights, environmental, and also social labor law away from states directly through international instruments to these companies. Thank you.
And I have a question that's following up on this, but also some angle that I was thinking about is when we're talking about private sector and indeed the responsibility they can take and how that's being put into the legal frameworks is, and I don't know enough about this, but about their responsibility to adapt. And I know a lot of companies will definitely adapt if it's affecting their own supply chain. Or they move their supply chain, which is also going to have a big impact on vulnerable communities because they're depending on these supply chains. We have tried to, at some point, have these conversations with private sector to just make them aware of how climate change is affecting their supply chains, but also the communities that they rely on, maybe not directly, but their workforce, and see if there's a way. And I know that probably isn't there yet, but to have them responsible of making sure the communities they rely on are also being supported to adapt to climate change, and not so much mitigation agenda, which is quite strong, I think, when it comes to private sector.
Yeah, I think there is, and there is more than meets the eye at this point. I have a number of studies that I could share with you where effectively it's almost now impossible to operate really as a transnational corporation without regard to ESG demands. That is not. It's not very happy, and there's not very wise, let me put it this way, for them. And there's increasingly a numbers of legal instruments being developed to actually enforce it. Now, a case that has just been brought here and won in the Supreme Court, UK Supreme Court, was about holding BP, which is a UK company, accountable for major oil spills in Nigeria and the delta there. And the interesting thing here is that this is just going in the same direction, where hard law is effectively backing up these soft law demands, but which are increasingly becoming important. But the interesting thing about this case is as well that the law reacts to the reality. So BP in this case had a subsidiary in Nigeria, and under traditional views, they would have been accountable and they were effectively bankrupt. So here, the plaintiffs brought the case directly in the UK against the headquarters, and the Supreme Court said yes, there is jurisdiction of the British courts under British tort law over this. So amazing, and there's lots of implications for this. One of them is, for instance, if you have a requirement of looking after what is going on, for instance, in say, if you have a subsidiary in Siberia being involved in extracting gas there, you can't wash your hands off the responsibility for that. When at the same time you say we're going towards a net zero carbon objective. Yeah, I think there are increasingly strong indications that these Paris Agreement objectives are percolating down through the value chain. And there's many things, as you rightly say, the value chain of clean energy doesn't, for instance, mean happy energy all the time. If you look at lithium and other raw materials that are needed, it's abject humanitarian problems in Congo and other places. So the value chain that is being established here raises all sorts of issues. Yeah. Okay. We can. I think that's probably where I leave it at this point.
All right. Thank you for engaging in such a deep discussion. Actually, I think it is very interesting for the participants as well. We have another set of questions that can be combined. They are raised by Lois Elwin and Pierre Thielberger. And the first part of the question relates to responsibility and asks whether it is possible that principles such as the polluter pays principles could be applied internationally and across state boundaries through international law. For example, do you foresee that a small island state such as Tuvalu could bring a claim against a big polluter such as China or the US through this principle? And building on that, could the responsibility of states be extended at some point to not only cover payments as compensation, but maybe even an obligation to make territory available? And if so, how would we select which states would have such an obligation? By the amount of greenhouse gas emissions, by the size of the territory? How do we decide who bears the obligation?
Maybe that's for Patricia.
I will answer partially, not to the two full questions. On the first one, I just want to make a comment on the question of whether Tuvalu could sue China or the US. Just want to, we're not discussing that in the International Law Commission, no mistake about that. And as I said, to make it very clear, we have left outside of the scope of our study any questions dealing with responsibility or liability. So we're really not looking at that. But that question, of course, it's something that has been discussed in the literature, but it has also been part of the political conversation and the political discussion, whether it would be possible to seek redress and in a judicial, by judicial means. And I think, of course, one has to be aware of the difficulties of finding the right forum to do it, because, of course, going to national courts, there's always the obstacle of state immunity, so that would be difficult. And then, of course, going to international courts, namely the International Court of Justice, the question of the acceptance of jurisdiction would be a difficult one, especially when one has in mind the two specific states that were mentioned in the question, that do not have an optional clause declaration, and the applicable treaties, the relevant treaties, probably do not contain obligations to settle disputes, or at least not the acceptance of those states with regard to a possible ICJ contentious jurisdiction. And that's why there have been so many or so often suggestions of an advisory opinion being requested, either from the International Court of Justice or even possibly ITLOS, on a more specific or narrow question regarding the pollution aspects and in the oceans, aspects covered by the UNCLOS regime. There have been, if participants are interested, there's been a very interesting series that concluded just last week, organized by the British Institute of International and Comparative Law, where precisely this question of what could the ICJ do with regard to these questions specific to sea level rise. In the ASIL meeting last week, there was also a panel on the possibility of bringing a case on climate change to the ICJ. And so I think there are some public campaigns, public opinion campaigns, and some states have been thinking, like Tuvalu, Palau, they've been thinking about bringing an advisory opinion request to the ICJ. But of course, to do that, it would have to be through a General Assembly resolution, and there would have to be an important diplomatic campaign in order to mobilize states in the General Assembly. And I think there would have to be also a very well drafted question to be asked to the court, because I think that would be the difficult part, would be what are we asking the ICJ on the issues of liability, responsibility for climate change, or in particular sea level rise. So that's what I wanted to say about the first question. On the second question, on if it would be possible to have other types of responsibility being engaged, or consequences of responsibility, like making territory available, and which states would have that obligation. I really view these issues much more, I would find it very difficult in practice that this would happen in terms of, a state being condemned by an international court to provide that kind of measures. Even if it was possible to have litigation on state responsibility or liability in this context, probably I would think that the best option would be that there would be a declaration of a breach. I don't think there would be any kind of restitution, reparation. So it would be more like in the satisfaction type of acknowledgement of a breach of international law. I would think, knowing the case law of international courts and tribunals, to have this kind of measures ordered by a judgment, I would see it very difficult. Where I think there's room for this type of measures is it's through international cooperation, it's through consents, and it's through states realizing that they have to do something to help the most affected states. For example, the idea that I suggested that sometimes appears in the literature, and which probably it's a pragmatic idea of having a merger of affected states with a territorial basis in a neighboring country. That could be an option along these lines, but that would only happen through a treaty, through agreement, through consent, through cooperation. The other idea, for example, of states, third states providing temporary protection, humanitarian visas, labor visas, I mean, those kind of programs at a bilateral level, regional level, or even a more international solution. But I think the solutions will be a lot at the practically they'll operate a lot at the bilateral and regional level. So I think the solution, the road is more through international cooperation, international agreements, consent, rather than looking for a court judgment that would bring this type of measures.
Yeah, if I do agree with this. Two small points. One is that there is, in addition to the traditional responsibility in the state responsibility in a narrower sense, there is an instrument that has been discussed in the climate change negotiations, compensation, or the Warsaw mechanism. And that's actually very innovative, and it is effectively a way of saying there will be disproportionate impacts on certain members of the international community, and we need to do something about this. This is without recognition of responsibility in the narrower sense, and it is not operational at this point, but this may be one way of advancing. And there's another doctrinal interesting question here about polluter pays. That's a very, very interesting question, because the instrument that the European Union is now discussing to effectively extend its emissions reduction program, which is called a carbon border adjustment mechanism, is based on this idea. So they say effectively, we have this system in place where our companies pay in order to because they are the polluters, they pay for the emission rights. And if you want to trade with us, then you need to also pay that same amount of money. So, China is actually now also introducing a carbon emission system. That's often overlooked, but they do. But Russia, for instance, doesn't. So if Russia wants to export goods or even oil or gas into Europe, they could be actually be required to acquire these emission rights from the Europeans on the idea of creating a level playing field. This is one of the hottest issues right now in world trade law, and it is the argument of the Europeans is to say, yeah, we accept that the Paris Agreement is about bottom-up determination of your ambition, but there is the idea of the common standard of polluter pays as well. So that is indeed potentially a route towards achieving more strict and more standardized mitigation measures across the world. Thank you.
Thank you very much. We have another question. I think a participant raised her hand, namely Lorraine Schröter. I will unmute you momentarily. You can now go ahead and ask your question.
Do you understand me or not? Yeah, it's okay.
Yeah.
First of all, thank you for the presentations. I've learned a lot and I have a lot to think about the next days. I have a more general question because I'm doing researches on the water legislation of the European Union, and I read a lot about the problem that in most states the economic evolution is still a priority, and we talked about big private actors too, which are still not caring enough about all the environmental problems. And regarding the other risks and dangers which will be caused in the future. So we are aware of the dangers which will be caused about global warming, and also that environmental law and human rights are coming closer together. I would like to ask how good the cooperation and the prevention between states, even on an international scale works, and how aware are private actors and states, and yes, how good do they cooperate for preventions and precautions, and even maybe taking a step back regarding economic evolution.
Thank you very much, Lorraine, for your question. Who wants to take this one?
Yeah, just a very brief point probably I can make here. Look, the economic actors will react if there is if the signal from the governments is clear. I think that's really the message. It must be irreversible. You know, the action that states want to take on climate change needs to be irreversible, and then you will see some reaction to it from the private sector, as I've outlined. So you wouldn't really expect cooperation in the sense that, you know, state and companies are different, but the key thing is to get to the to align, I think, the strategies of corporations with the objectives that governments set. So I think there are signs for hope in this direction.
Perhaps if I just may add on the state-to-state cooperation, I think we are still in a phase where this issue is being looked at much more closely by the states that are in the front line, that are more directly affected and that are already feeling the impacts. And that's why the Pacific Island states have been so vocal, because they are really already experiencing the impacts. I think that there will be a point and where we see that there's a more emergent practice, both with regards to the law of the sea issues and to the protection of persons, and also some thinking going on about what happens if the state disappears or becomes inhabitable. This is happening mostly in the context of Pacific Islands, and the Pacific Island Forum has had a very important role in trying to harmonize and coordinate positions, and at the same time, what we see at United Nations is, for example, AOSIS, which is the Alliance of Small Island States, which is a more broad organization, because it covers also small islands in the other parts of the globe, also in Africa and the Caribbean. They're also being very keen in taking positions in this matter. So we see that the states that are more directly affected, and they are in the front lines of the climate change impacts, they are more aware and they're looking for solutions, and they tend to cooperate more. I think there will be a point where the states that are not directly affected, but may be indirectly affected, because they may then experience also population movements into their countries, they will become also interested in finding solutions and in cooperating more. But I think we're still in the first stage. I think there's a recognition that this is a global problem and that needs a global solution, but in terms of a more operational cooperation, I mean, there are some arrangements between states that have, for example, special links. For example, there's a program, a visa program allowing for some citizens of some Pacific states to go into the US, for example, because there are strong links between the countries. But I think we're not yet in a stage where more international cooperation is fully operational, because the effects are not felt also in those states. But I think that here, as I said in the previous answer, this is an area where international cooperation is going to be key to solutions.
Thank you. I hope this answered the question to your satisfaction, Lorraine. As we move towards the 90 minutes mark, there is a couple of more questions. The first one tries to draw inspiration from tort law when it comes to the responsibility of big emitters. And the question essentially asks that since in tort law, rules for causation and negligence are linked to the requirement that the loss needed to be reasonably foreseeable, whether something can be drawn from this tort law principle for holding big emitters responsibly. I would anticipate that this might go into the direction of the importance of environmental sciences for the evolution of international law that Volker alluded to, but I'm nevertheless excited to hear the answers of the panelists.
Yeah, this is a fascinating question. A couple of colleagues and I have done focus on this question of causation, which pops up all the time in this Peruvian farmer case and others as well. You need to very dig into the tort law to understand where you can make progress. In fact, it's possible that if you use the concept of attribution science, there's a major advance in that scientific understanding of the causation of the causational links in the between emissions and eventual consequences. It's called attribution science. There's a couple of colleagues in Oxford doing this. And then you need to unpack the concept of causation that we have inherited from tort law. You can get to some very interesting insights. And if you want to, I can share an article with you that tries to develop just that question.
All right, thank you, Volker. There is a question now addressed specifically to Sanne, and it goes like this. Does the education of humanitarians take climate change as a factor in humanitarian action sufficiently into account? And if not, what knowledge and what abilities should be taught more to people who want to become humanitarians?
I think it's a very good question. And we see that, at least I can speak for the Red Cross movement mainly, is that that has changed a lot over the recent years. And the countries that are most at risk of climate change are definitely, teaching their volunteers and staff members about climate change, but also how to take short and longer term risks into account when designing programs, etc. You see that growing quite a bit. But if I would look, for instance, at the Netherlands Red Cross, that expertise is maybe quite limited, maybe not in the international department, but so for more in the national department, while there is also quite a lot to do on the national front. And yeah, let me see if I can see what the last part of the question was, is if not, what knowledge and ability should be taught? Yeah, I think it's about what I think said in my conversation is like how to assess risks and also what are good solutions for long-term and short-term risk reduction. And I think that's becoming much more part of practice in a lot of, at least in the Red Cross national societies. And answer for many other humanitarians at this point.
Thank you for taking this question, Sanne. Looking at the Q&A section, as well as the chat, it appears that all the questions raised by our participants have been answered. So unless anyone wants to raise a last-minute issue, for which I would provide the opportunity now. All right, that doesn't seem to be required. Then I would once again like to thank all of our panelists and the participants of today's webinar. I think you contributed to making this a great success. Thank you for the insightful presentations and the lively discussions. And I also want to extend my gratitude to the Institute's research cluster on humanitarian governance and protection, without which this event would not have been possible. Thank you for joining us, and see you the next time. Bye-bye.
Thank you very much.
Thank you.